So recently I had a consult with someone who had a refusal of their study permit application. And the client was obviously frustrated, not understanding why his application was refused in the first place. I'll have to add here that the refusal letter was really vague to a point where it almost seemed absurd. If you ever had a refusal from IRCC yourself, you probably know what I'm talking about, how those refusal letters can be useless and not provide any clarity whatsoever. So essentially the client wanted to know what can be done to challenge this refusal. Could his application be saved, or he had to reapply all over again? In this video, we'll talk about refusals in detail, and we'll discuss 3 options available to you if you had your immigration application to Canada refused by IRCC. So without any further ado, let's dive right into this topic. Essentially, as I've mentioned before, you have 3 options to overcome a refusal. First, you can reapply, or you can send a reconsideration request, or you can challenge the refusal in the federal court. You can pursue just one of these options, a combination of 2, or use all 3 options at the same time. But your strategy will really depend on a number of factors, such as why your application was refused in the first place, how much time and money you have to fight the refusal, and obviously, what is your long-term immigration strategy. So let's talk about reapplying first. This is the most obvious and often the easiest option of all 3. Basically, after getting a refusal, you can submit a new application where you correct the mistakes or make necessary improvements to address the concerns of the officer. For example, if, let's say, you had a visa application refused for insufficient funds, you can potentially reapply and provide more evidence to show that you have enough money to cover the cost of your upcoming trip to Canada. The same principle would apply if, for example, you have a refusal for lack of ties to your home country. This is a notorious and very common reason for refusal, and again, you can reapply and provide more evidence to the officer to show that you perhaps have some real property, stable employment, family commitments, or any other ties to a country of origin that would require your return from Canada. It's a little more challenging if the refusal letter is really vague and does not explain why exactly the officer decided to refuse your application. In our practice, we see many clients with very generic refusal letters, and often these refusal letters don't even make sense. Typically, they say something like, the purpose of your trip to Canada is it's consistent with your temporary stay. And that's it. No other hints, no explanations whatsoever. So in these situations, we often critically review the submitted application and try to put ourselves in the shoes of the officer to see how the officer would arrive to this conclusion. Was there something missing, or could the application be improved? So realistically, before you consider reapplying, you would need to know a little more details as to why the officer decided to refuse your application. Often just taking a look at the refusal letter is not enough. So besides reviewing the application, we at Holthe Immigration Law often submit ATIP requests to obtain the GCMS notes. For those of you unaware, the GCMS notes contain a detailed log of all actions taken on your file and provide more detailed explanation of the reason why the officer decided to refuse your application. The problem, however, is that it may take weeks or even months before you get your GCMS notes back. So if you choose to wait for your notes and then reapply, you may miss on other alternative options for challenging the refusal. Just a spoiler alert, if you want to judicially review your application, you only have 15 days if your matter is arising from inside Canada and only 60 days for outside Canada applications. But we'll talk about the tight deadlines later on in this video. All I want to add here is that if you choose to wait for the GCMS notes, you have to understand a very high chance that by the time that you get your notes, you will lose your chance to judicially review your application. Not trying to say that you shouldn't request notes, but you have to be mindful of the typical and long timeframes for getting your response to the ATIP request. Now, you wonder, why would you even consider reapplying as your primary and preferable option? Well, there are 3 reasons. First, reapplying is relatively simple, cheap, and fast. All you have to do is take your previous application, correct your mistakes, or add more information that can make your application stronger, and then resubmit it to IRCC. Pretty much you start fresh all over again, and if you did your homework well, there is a chance that your application may get approved the next time. On the other hand, reapplying may not be even an option for some candidates. For example, if you had your permanent residence application refused, you may not be eligible for another ITA, or let's say you applied under a temporary public policy and the policy is now expired. So in this scenario, you cannot reapply at all. Asking for reconsideration or challenging the refusal in federal court might be your only options. Alright, this now brings me to your second option for fighting the refusal, which is submitting a reconsideration request. Perhaps this might be the most accessible and least expensive option of all three. And I have to be more specific here. It is actually absolutely free to submit your reconsideration request if you do it yourself. Essentially, a reconsideration request is a letter that you write in a free format and you send it through the web form to an immigration officer where you ask to reopen your application and reconsider the decision. Practically speaking, reconsideration requests are only effective if there is a clear mistake made by the officer. For example, you applied for a program under temporary public policy and the officer refused your application because supposedly you were ineligible. Well, you may submit a reconsideration request where you explain why you think you are in fact eligible and show the officer where he made a mistake. At the end of the letter, you can then make a kind request to the officer asking to reopen your immigration application. Now, speaking about potential drawbacks with reconsideration request, two things come to mind. First is time, and second is discretionary nature of these type of requests. Again, the letter must be sent through the web form, and if you sent a web form, you may know how long it takes before your web form even gets to the officer. So it may take weeks before the officer even sees your request. And even then, the officer is under no obligation to reconsider your application. Essentially, the officer might skim through your letter and then, surprise, surprise, decide not to do anything on your file and leave the refusal in force. Even more, IRCC will typically not even send you a response informing about the results of your reconsideration request. So you may end up in a situation where you sit and wait for weeks to hear back on your reconsideration request and you don't get any response ever. Again, we have been successful with many reconsideration requests, but it's really important how you lay out your facts, how you clearly explain your position, and how you highlight the mistake that was made by the officer in assessing your application. Yes, as ironic as it may sound, even immigration officers make mistakes. We have seen a lot of refusals of postgrad work permit extensions where officers mistakenly misinterpreted the applicant's status in Canada or determined that the applicant was ineligible for the public policy. In these situations in 2023, almost all of our reconsiderations requests were successful. On the other hand, when, for example, your study permit application was refused because the officer reviewed your application and concluded that you have very weak ties to your home country, or if your program does not make any sense, it is rare that the reconsideration requests are successful. This being said, we often would submit a reconsideration request as our last hope to get a refusal overturned before we proceed to option number 3, which is challenging the refusal by way of judicial review in the federal court. Filing for a judicial review is by far the longest and the most complicated and expensive option of all three. However, just as with the reconsideration request, for some candidates, filing for a judicial review may be the most logical approach. Now, there are a few things you have to keep in mind when considering a possibility of filing for a judicial review. First is the tight deadlines. As I mentioned earlier in this video, you have only 15 days if your matter is arising from inside Canada and 60 days for outside Canada applications. If you don't submit your application to federal court on time, you may be out of luck. This is why it is absolutely critical that you reach out for help to an immigration lawyer as soon as you get a refusal. In our practice, we do quite a few judicial reviews and we can help you build out a strategy and advice on how exactly you can overturn a refusal in your specific situation. So don't waste your time and book a consult as soon as you get a refusal letter. Okay, the next thing you have to be mindful of is that a judicial review is a complex and lengthy two-tiered process. At stage 1, when filing a judicial review application at the federal court, you must submit a formal application and then prepare the application record, which is essentially a large, often more than 100 pages long document with facts, affidavits, arguments, and law explaining why your application should be allowed. The court will then decide whether to accept and grant you leave for your application. If you obtain leave, which is essentially an acceptance or think of it as a permission from the federal court, you will then proceed to the second stage, where you will have a hearing before an immigration judge at the federal court. In the end, the judge will either dismiss your application or will order your application to be reopened and redetermined by a different officer. Yes, it is important that you understand that federal court does not approve your immigration application and cannot guarantee that the new officer will approve it. Essentially, if you are successful at federal court, you will be back to square one waiting for the new officer to reconsider your initial application. The good note, however, is that you can always ask the judge to allow you provide additional supporting documents, and the officer will also be a little more considerate having regard to the decision of the court. So after all, judicial review may be an effective tool that you can use to fight a refusal, especially if the reason for the refusal was very vague and unreasonable. All right, you're probably also wondering how long does it take to get through the judicial review process? And that is a valid concern, so we can do a rough calculation here. Let's assume you've got a refusal on January 1st and you filed your leave application by February 1st. You will then have to wait for the so-called Rule 9 reasons, which is essentially the excerpt from a decision of the immigration officer, very similar to the GCMS notes, and it can take about 1 to 2 months to get the reasons. So by the time Rule 9 reasons come in, it's already April 1st. Next, you have 30 days to prepare the application record where you present your arguments, and let's assume you do that by May 1st. Then the respondent has another 30 days to prepare their memorandum, and this brings you all the way to June 1st. And then it can take another month or so to get the hearing, and realistically, maybe you can get a decision on your application in fall of that year. If you're successful, your application will go back into processing again, and it can take another few months to get a decision. Just to demonstrate how long it can take to get through federal court, here's an example of a random recent case where the leave application was filed in June 2023, and the final decision was made almost 1 year later. So before you proceed with the judicial review, it's very important that you understand how long the process can take, and that it does not guarantee anything. It can easily go for 1 year or more, and during this time you can potentially reapply at least a few times. So choosing your strategy wisely is really important. All right, and finally, when talking about judicial reviews, it's also important that I mention settlement here, which is an ideal scenario when we proceed with judicial review applications. Essentially, settlement is an offer that can be made to the respondent, which in our case would be IRCC, where we propose to avoid going to court and ask IRCC to reopen application and send it off to a different officer. Settlement is in fact a good win-win solution for both parties, as it allows to save resources, time, and money for the applicant and for the respondent. Often we are successful with settlement offers early on in the process, but on some occasions we don't reach settlement until we file the application record at federal court. There are also files where we can't reach settlement at all, and we have to go through the whole process start to finish, which, as you can see, takes months or even years. After all, it's really dependent on the specific circumstances of each case, but if we reach settlement, it is a big win that helps our clients get a positive result fast and save on unnecessary fees. We basically discontinue the application and IRCC reopens your refused application, often allowing you to provide additional documents to further improve your file. Well, there you have it. Just to recap, if you have a refusal of your immigration application, you have essentially 3 options. You can either reapply, submit a reconsideration request, or go through a judicial review process at a federal court. Often, you would do a combination of at least 2 options, submitting a reconsideration request and then filing for judicial review later on. But essentially, you have to be strategic and fast in deciding how you want to proceed with your refusal. So if you consider challenging the refusal, you can click the link in the description under this video and book a consultation where we will help you choose the best course of action for you. I hope this video was helpful, so don't forget to subscribe, like this video. If you have any questions, you can leave the comment, and then I'll see you in the next video.